So you have been the parent or the babysitter who's using ecstasy every day, babysitting your children, and that means you're not a good parent. Because if you thought you were a good parent and using ecstasy, you would allow someone to babysit your children who use ecstasy. Do you understand?
All right, y'all, brace yourselves because this one hits where it hurts. In Judge Boyd's courtroom today, we're not just talking about crime, we're talking about parenting, addiction, and brutal honesty. Leroy Johnson, a father of 3, steps up and admits something shocking. He's been using ecstasy every single day, but here's the kicker. He still insists he's a great parent. You can feel the tension shift. Judge Boyd isn't having it. She doesn't yell, doesn't lecture, but what she does do, she flips the entire conversation with one powerful analogy that leaves the courtroom stunned. In just a few words, she tears down every excuse, every claim about parenting classes, good intentions, or probation worthiness and replaces them with a dose of truth that hits like a freight train. This isn't just a sentencing, it's a wake-up call. If you've ever wondered where the line is between being a parent and being a danger to your kids, this is the case that makes it painfully clear. Let's get into it.
Court is calling 2022 CR 10140, State of Texas versus Leroy Harvey Johnson. Could I have parties announced for the record for the state?
Jason Dorgans for the state.
Robert
Defense?
Clark for Mr. Johnson.
And are you Mr. Johnson?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're just waiving the allegation that there was a deadly weapon used in this case.
Oh, so you're waiving the enhancement?
I don't know if it's exactly an enhancement, but yes, that allegation, Your Honor, the second paragraph.
Okay. Any objection? All right, Mr. Johnson, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
No.
Did you understand you're charged with deadly conduct firearm as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is waiving the deadly weapon allegation. They're asking that your punishment be assessed at a cap of 6 years in the prison. They're remaining silent on your application. They are taking in consideration 2022 CR 10141, 2022 CR 10142. There's to be restitution, if any, to Hector EA. Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. At this time, we offer State Exhibit 1, the defendant's waivers and stipulation of evidence, as well as the discovered acknowledgement for this case.
No objection.
All right, Mr. Johnson, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. We will come back on February 9th. At that time, I'll make a decision on your application. My decision will be based upon any evidence that's presented to me and the PSI report. Does your client need a TAP evaluation?
He does, Your Honor.
All right, so State, it's going to be a PSI report and TAP evaluation.
Thank you, Your Honor.
All right, thank you.
I'm out of breath, Judge. So.
All right, Mr. Johnson, come forward. And do you know if the state had a chance to review the TAP evaluation?
I don't know if the state did, I did.
All right, who's the representative of the state on Leroy Johnson?
It was Jason. Jason.
Leroy Johnson? It's sentencing?
Okay.
Okay. All right, you ready, Deanna? Court is calling 2022. If everyone could please whisper, 2022 CR 10140, State of Texas versus Leroy Johnson. You entered a plea of no contest on January 19th. You made an application for deferred adjudication. According to the plea bargaining agreement, the state waived the deadly weapon allegation. Punishment was to be assessed at a cap of 6 years in the prison, and the state is silent on your application. They're taking certain items into consideration, and there's to be restitution, if any, to Hector. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, any objections to the PSI report?
Not from the state, Your Honor.
Defense?
Your Honor, yes.
All right, what are your objections?
We're standing before the court saying that the court is being misled as far as the TAP evaluation.
Right, I'm sorry, just a moment. Excuse me, in the box, if you all could either whisper or not speak in the box while we're on the record so that the court reporter can hear. All right,
I'll speak up a little louder, Judge.
thank you.
We're going to stand before the court and say that the TAP evaluation is not correct, nor if anything else was correct as far as the drug use is concerned.
All right, so what is your correction to the TAP?
He does have a drug issue, Your Honor. Ecstasy and meth daily. At issue, Judge, is we visited about what was going on and why we're doing what we're doing today is simply this. You know, Mr. Johnson was always thinking, okay, what's the easiest way that I could get out the quickest time to get. After he did this evaluation, we got to think about it. I said, no, I need help. I need to do that so I can quit lying to myself and quit lying to society, quit lying to everybody. And I said, well, you've told him this, and that's not true, and that isn't true. And I want drug help. So I guess my objection would simply be that when they're sitting there saying that there's no recommendation that it's cannabis use and then alcohol way back when. It is true he doesn't drink alcohol at all or use marijuana much, but he uses ecstasy and meth.
All right, anything else with regards to the actual report?
Everything else is fine.
All right, anything you wish to say on behalf of your client?
Your Honor, having said that, it was refreshing to actually have an individual sit there saying, have reflection, and I'm sitting there and sit there and say, you know what, this is crazy for me to be doing what I'm doing. I do want help. So we're respectfully requesting this court to grant his application for giving drug treatment.
All right, so what the court has concern about is number 8 in the PSI report. It's on page 5. And I'd like to know what is meant by this type of behavior before. That's what the complainant is saying. The complainant says that he's engaged in this type of behavior before.
No. Well, Judge, I don't think I could speak.
I'm so sorry. That's me misreading. He stated that if the defendant has a history of this type of behavior, he does not think he should get probation. But if this wasn't an isolated incident, he can understand him being given another chance.
Right. So
I'm sorry, my misreading. So, Mr. Johnson, you waived your right to remain silent when you entered this plea. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth to help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record, please.
Leroy Johnson.
All right. So I'm gonna need you to speak up so that I can hear.
Oh, Leroy Johnson.
So explain to me about your drug use.
I take ecstasy every day, like all day. That's it. So much ecstasy, I get delusional.
I can't hear you.
I said after so much ecstasy, I guess I went delusional. Went outside. Shoot.
Are you in your children's life at all?
Yes, ma'am.
Why? Because it doesn't appear that you're a good parent.
I don't always do that. I went delusional. I was seeing her.
No. I want you to focus on the questions that I'm asking.
Yeah.
My next question for you is, are you in the lives of your children?
Yes, ma'am.
How often had you been seeing them before this?
I had my children there all the time on the weekends and holidays.
Who's letting you have children on the weekend and holidays when you use ecstasy daily?
I'm still a good parent.
All right, let me ask you a question. How old are your children?
10, 7, and 8.
All right, so they're 10, 7, and 8.
We're going on, 10, 7, and 6.
10, 7, and 6, right? All right, so let's say you're going to have your children for the weekend, and you want to have your children for the weekend. An emergency comes up, and the mother of the children and no other relative can keep them. But somebody tells you, hey, I know someone who's a great babysitter, and it's me. They tell you, get Stephanie Boyd. I know you have your emergency. She's a great babysitter. You say, I don't know. And somebody says, well, let me give you her references. They give you my references. You call and check. Everybody says, Stephanie Boyd is a great babysitter. And as a matter of fact, she's the best babysitter in the world. And you say, well, I still don't know. Let me just have her come over and see if my children like her or not. So you stay with me and you stay with the children for an hour. The children love me. They're all over me saying, Daddy, please let her be our babysitter while you go off on this important thing you have to do. And finally you say, okay, Stephanie, I'm going to want you to call me every hour, but I'm going to let you babysit my children because children like you. And I got all these great recommendations from everybody saying you're great. You don't have any criminal history. I'm going to let you babysit my children. And I'm excited because you're saying, I'm going to pay you $70 an hour. I'm like, great. And so as you're leaving, I say, well, there's something I really need to tell you that you may not know about me. I use ecstasy every day. When I tell you that, do you let me babysit your children?
No.
So you have been the parent or the babysitter who's using ecstasy every day, babysitting your children. And that means you're not a good parent. Because if you thought you were a good parent and using ecstasy, you would allow someone to babysit your children who use ecstasy. Do you understand? So I will tell you this. I'm going to give you a choice. And Mr. Porter will tell you, sometimes I can give people choices, sometimes I cannot give them choices. I can place you on probation. I'll give you a deferred adjudication, but you're going to safety because felony drug court will not accept you. We can have them look at you, but they're not going to accept you because of this gang affiliation issue. So you can either wait and go to SafeP. SafeP is a 9-month program. SafeP, you're going to spend 6 months inside the facility. And then there's 3 months of aftercare. So you can do that, or I will sentence you to 4 years prison. So you can discuss that with your attorney. Mr. Porter, do you need to discuss that with him?
I would like to, Your Honor.
Okay, thank you. Yes. All right, Mr. Porter, you all can come back up. All right, so we are back on the record in 2022 CR 10140, State of Texas versus LeVar Johnson. Has your client made a decision?
Yes, Judge, it was a quick decision. He had already paid up with this, he just wanted to go some legalities of it, but he got the truck.
Okay. All right, then this is what the court will do. Court will sentence you to 8 years deferred adjudication. I'm going to want gang supervision, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors, Mr. Porter. Once he's in his sobriety, then the court may consider that. But for now, no unsupervised contact with minors. Ms. Abrams, I don't know if Child Protective Services is involved in this case or not, but if they are, I'm going to want CPS compliance. I'm going to want regular reporting by Zoom or in person, field visits 3 times per month, a referral to felony drug court, and if he's not accepted in felony drug court, then I'm going to want safety, and he's to remain in custody until accepted in felony drug court or safety. There's to be restitution and no contact with Hector. Taking consideration 2022 CR 10141, 2022 CR 10142, the UA hotline upon release, and he's to be tested at least once a week. And state, you can, I'm sorry, state, I meant probation. You can lower that as you all see is appropriate. And I'm going to want 90 meetings in 90 days upon release. Probation, is there anything else he needs? I'm sorry, parenting classes. And those parenting classes will be with Triple P. 250 hours of community service restitution. The remaining hours will be waived upon completion of parenting classes. Probation, is there anything else he needs? Is there anything else you need for me to be successful on this probation? All right, why you have your head back like you're trying to be hard with me? All right, so do not come to the court trying to be hard, because this is not the streets. You understand? Do you understand? All right, thank you.
Man, this one wasn't easy to watch, but that's exactly why it matters. Judge Boyd wasn't just laying down a sentences, he was delivering a lesson, a hard one. And sometimes, the truth hurts a lot more than prison time. So here's the real question. Can someone using ecstasy daily still be a good parent? Can love for your children cancel out active addiction? Drop your thoughts in the comments, let's talk about it. These are the cases that force us to face the uncomfortable, and sometimes that's where real change starts. Until next time, stay clean, stay focused, and I'll see y'all in the next one.